Just trying to get everybody's attention. The Committee on Education and Workforce will come to order. A quorum being present, the committee meets today to consider H.R. 3441, the Save Local Business Act. Given time constraints, I ask members to insert any written statements into the record. I'll hold the record open until the end of the day in order to accommodate those members who may not have prepared written statements. I now recognize myself for an opening statement. Good morning again. As we meet this morning, we are all still heartbroken and shocked over the horrific tragedy in Las Vegas. We pray for the innocent lives lost, their families, and the wounded still in the hospital. And we're grateful for the bravery and heroism of the Las Vegas police, the first responders, and the medical personnel. May God bless everyone impacted by this terrible and senseless act of violence. Today, the committee will consider H.R. 3441, the Save Local Business Act. Since the National Labor Relations Board unilaterally redefined what it means to be an employer in 2015, more than 24 witnesses have come before this committee and others in Congress to tell us in practical terms what the decision means for the future of American jobs. We've heard firsthand how the board's decision and the actions of regulators and activist judges that followed have disrupted the daily operations of business owners across the country. The consequences have been far-reaching. Basic business-to-business relationships that have long been a part of the American way of life and a critical component to the success of our economy have been called into question. The lines of responsibility for important worker protections are now blurry. Small business owners fear they will lose the independence they work so hard to achieve. Others who rely on contracting opportunities fear their options for growth, along with their limited stream of revenue, will suddenly diminish. Meanwhile, many hardworking men and women are left wondering why the relationship they have with their employer is changing, or if unelected bureaucrats or activist judges will dictate that they have a new boss at some distant company. And that's not all. While we've all been working together here in Congress to support workforce development reforms, we've simultaneously heard how the joint employer scheme makes it harder for employers to do their part effectively in addressing our nation's skills gap. All of this damage began with one extreme and obstructive ruling. We wouldn't be here today if the overwhelming consensus wasn't that the NLRB and Obama-era bureaucrats made serious mistakes. We're here today to complete one of the most important steps in correcting those mistakes. Mr. Byrne has introduced the Save Local Business Act with the support of most of the members of this committee. The bill directly addresses the mistakes the NLRB made when it redefined the concept of joint employment and put so many jobs and livelihoods at risk. And it addresses the mistakes the Obama administration made when it spread the board's flawed policy to other areas of federal labor law. Both of our workforce subcommittee chairmen, Mr. Byrne and Mr. Wahlberg, have carefully examined the statutes under their respective jurisdictions. They worked together to ensure that the scope of the bill under consideration today appropriately clears up the existing confusion and restores the common sense concept of joint employer for businesses of every size. American workers deserve to know who they're dealing with in their workplaces. They should have the power to speak for themselves on matters of pay, schedules, professional development, anything that helps them have the successful life they want for themselves. In order to do that, they need to know with certainty who their employer is. But both employers and employees have made clear to this committee that the current joint employer standard is confusing at best, devastating at worst, and simply not sustainable. We've heard them, and that's what leads us to where we are today. I thank Mr. Byrne for his hard work bringing the Save Local Business Act this far, and I thank all of our members for being here and for ensuring the joint employer problem and this solution get the thorough attention they deserve. I now yield to Ranking Member Bobby Scott for his opening remarks.
Thank you, Madam Chair. And Madam Chair, I first join in your condolences to the victims of the senseless violence in Las Vegas. Madam Chair, the bill we're considering today would eviscerate worker protections under the National Labor Relations Act and the Fair Labor Standards Act by eliminating longstanding avenues for workers to recover stolen wages and secure recourse for unfair labor practices. Labor and employment laws have long provided recourse for workers who have joined employers, a situation that arises when more than one entity controls the terms and conditions of employment. Joint employment standards in the NLRA ensure that workers can collectively bargain with all of the parties that control the terms and conditions of employment. Similarly, joint employment standards under the FLSA ensure that appropriate companies can be held accountable for violations that pertaining to anything from wage theft, equal pay, and overtime. Joint employment arrangements are only becoming more common as the workplace is increasingly divided through the use of so-called permatemps, subcontractors, and employee leasing arrangements, and the committee should ensure that workers' rights are not eroded by this trend. The bill we're considering today is rooted in the misplaced criticism of the NLRB's 2015 decision in Browning Ferris Industries, where the NLRB held that the client employer, BFI, and its staffing agency, LeadPoint, were joint employers at the municipal recycling facility and therefore jointly had the duty to bargain with the Teamsters Union. BFI kept the wages that LeadPoint could pay workers, set the line speed and scheduling, and reserved the right to overrule LeadPoint's hiring decisions. The NLRB had certified a union with only LeadPoint as the employer, then collective bargaining would be a waste of time because LeadPoint lacked the ability to bargain over these key matters without BFI's permission. In this case, the NLRB reinstated the traditional standard of a joint employer, which it had applied consistently throughout its history up until it was inextricably narrowed by the board in 1984. This traditional standard is rooting in common law of agency and was expressly called for in the conference report to the Taft-Hartley employment relationship. Is designed to ensure that companies are not able to evade accountability by using intermediaries, labor brokers, or layers of subcontractors. Employers have no need to fear this standard unless they violate the law. H.R. 3441 rewrites both NLRA and LSA by adding a new narrow definition of joint employer. Under the definition, a person may only be a joint employer if they directly, actually, and immediately exercise control over 9 listed terms of employment, including hiring, firing, determining rates of pay and benefits, day-to-day supervision, assigning work schedules, positions, tasks, and administering discipline. If an entity controls all of these terms except one, then it might not be a joint employer under the definition. Even if the entity determines pay, it may not be liable for wage theft under the Fair Labor Standards Act. Alternatively, the entity could control all of the terms, but if it exercises that control indirectly through a subcontractor, then the entity is still immune from liability under the bill. Under the NLRA, this would cripple a union's right to negotiate with the entities that actually control the terms and conditions of employment. This also leaves employees without recourse for wage and hour violations. The bill goes even further. If there are 2 employers exercising control over an employee's work, both entities can deny being an employer for the purpose of a wage theft claim. Then the employee will have no employees with liability for violations. At our committee hearing on September 13th, I raised this concern, and a labor law practitioner who had litigated joint employer claims on behalf of low-wage workers testified that it is possible that there would be no employer liable for violations under this bill in cases where there are multiple employers responsible for different aspects of employees' hiring, pay, and discipline. And so a court could find that overtime had not been paid, but then look up and find that there are no employers liable for the payment. He explained that one company in charge of hiring, for example, one company is in charge of hiring, another sets wages, and both companies share responsibility, then neither company would control all 9 terms of employment. The employer goes to court, both companies can say they're not the employer, and the bill provides the judge nor the NLRB with any guidance how to resolve the problem and find somebody who is liable for the violation. A judge could find that an employee wasn't paid overtime, and also nobody owes back pay for the overtime payments. HR 3441 could set off chaos and impose needless harms to employees trying to navigate our legal system. I appreciate that the majority has apparently noticed this and attempted to deal with the problem. I understand that they'll be offered an amendment in nature of a substitute, which creates even more confusion because an entity is not a joint employer unless it exercises, quote, significant control over essential terms and conditions of employment. However, it is still unclear how a court would read these 9 enumerated conditions. Are all necessary for the party to be liable? Alternative, how many, if it's not all, it does say terms, plural, and conditions, plural. Do you have to have at least 2, a majority, or what? The bill provides no guidance on these essential questions and probably offers more confusion than the underlying bill. September 13th hearing on this bill also debunked the argument that joint employer standards threaten the independence of franchisees. The NLRB has long held that a franchisor cannot be a joint employer if it only governs brand management standards. Whether it is a joint employer only depends on whether or not the franchisor would control directly or indirectly the terms and conditions of employment. Indeed, no franchisor has ever been found to be a joint employer with a franchisee under either the NLRA or the LSA. In fact, the NLRB and Browning-Ferris plainly stated that the decision does not affect franchising. Despite that, a well-organized campaign has been sprung up linking the decision to unfair labor practice complaint that named McDonald's USA as a joint employer along with its franchisees. The question of McDonald's liability is still pending before an administrative law judge. The outcome of this case is unknown, and in any event, the complaint was issued under the pre-Browning-Ferris standard that the majority appears to claim that it prefers. The title of this bill, the Save Local Businesses Act, is misleading, despite this claims that HR 3441 will protect the independence of franchisees. We learned at 4 hearings over the past 4 years that the bill will insulate franchisors from liability when leaving the franchisees solely on the hook by decisions required by the franchisor. The franchisor mandates a policy that would violate the NLRA or the FLSA. The franchisee is forced to accept shared control without shared responsibility. The bill shields franchisors at the expense of franchisees. So, Madam Chair, I'm troubled that this committee is advancing legislation that is tailored to protect a defendant in the middle of a pending administrative law proceeding at the NLRB. It may be that McDonald's was intimately involved in controlling its franchisees' labor relations, or it may be found that no liability exists. Determination on the facts and law has not yet been rendered, and rushing to legislate without the facts is premature. Although we may disagree with each other on the merits of this legislation, I would thank the chair for pursuing regular order. I urge a no vote on the bill and yield back the balance of my time.
Thank you, Mr. Scott. The committee will now proceed to consideration of the bill, H.R. 3441, for amendment. Without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. I will soon recognize Mr. Byrne to offer an amendment in the nature of a substitute. Without objection, the amendment shall be considered original text and open to amendment at any point. The amendment in the nature of a substitute has already been distributed and is in each of your folders. I now recognize Mr. Byrne for 5 minutes to explain the substitute.
Thank you, Chairwoman Fox. I want to echo your comments and those of Mr. Scott regarding the tragic event in Las Vegas. Our prayers remain with the families who lost loved ones, and I want to express my deep appreciation and gratitude for the first responders and regular Americans who ran into danger and helped those in need. I was proud to introduce the Save Local Business Act because it's good for workers and it's good for job creators. And I appreciate the opportunity to speak in support of this common sense proposal today. As a former labor attorney, I can tell you it used to be pretty clear who an employer was. But now, 2 completely separate employers can be considered joint employers if they make a business agreement that indirectly or even potentially impacts employees. Those are certainly vague terms, so vague that many lawyers may not even agree on exactly what they mean. But we know that the real-world impact has been confusion, uncertainty, and growing legal jeopardy. Here's what those terms means to the owner of Winsel's Oyster House in my district in Mobile, Alabama. The owner, Bob Omansky, wrote recently in Alabama Today, and I quote, "If we hire an outside landscaping company to keep our lawns lush, I could be considered a joint employer if I show the landscapers where to mow. Or if I contract a food supplier for certain ingredients, I could become part of a lawsuit if one of their workers complains about overtime pay. The uncertainty is nothing more than governmental overreach that is crippling eateries like Winsel's and discouraging growth throughout the restaurant industry," close quote. There are small business owners in all of our districts who are working hard each and every day to create jobs and contribute to our local economies, and they deserve better than this. They deserve clarity. Workers deserve better too. They deserve better than an extreme and unworkable rule that threatens 1.7 million jobs. And they deserve better than unelected bureaucrats interfering with their relationship with their employer for the sole purpose of empowering union and trial lawyer interests. That's right. This joint employer scheme was really intended to make it easier for big labor to organize small businesses. It's no surprise that some of the nation's largest labor unions have been peddling scare tactics and spreading false information about H.R. 3441. So let me be clear on what the bill does. H.R. 3441 maintains existing worker protections under the National Labor Relations Act and the Fair Labor Standards Act. We are amending the NLRA to roll back the Browning-Ferris decision and prevent future NLRB overreach. And we are amending the FLSA because aggressive trial lawyers and activist judges have made matters even worse by creating a confusing patchwork of joint employer standards across the country. Again, this bill does not take away a single protection from a single worker. Instead, it ensures the actual employer is legally responsible for providing these protections. If everyone is responsible, no one is. Some have wrongly claimed that the joint employer standard reflected in H.R. 3441 is somehow a dramatic departure from long-standing policy prior to the NLRB's 2015 ruling. That claim is quite frankly absurd. I'd like to remind the members of this committee that it was the Browning-Ferris decision and actions by the Obama-era bureaucrats that completely disrupted what was once a stable legal environment and threatened countless local business as a result. H.R. 3441 simply restores the common-sense joint employer standard that workers and employers relied on for decades. It clarifies that two or more employers must have an actual, direct, and immediate control over essential terms and conditions of employment to be considered joint employers. The bill as introduced is consistent with case law prior to BFI, and today's markup presents an opportunity to make the bill even clearer. That's why the substitute amendment I'm offering makes clarifying and technical changes to the underlying bill. I urge all members to support the substitute as well as H.R. 3441, and I yield back the balance of my time.
Thank you, Mr. Byrne. Does any member seek recognition on the substitute? Mr. Scott.
Thank you. Thank you, Madam Chair. Madam Chair, this amendment in nature of a substitute is slightly different than the underlying bill. We've had all of our hearings on the underlying bill, and we've obviously exposed problems with the underlying bill that required the amendment in nature of a substitute. My question really is whether or not the amendment in nature of a substitute solves the problems or makes them worse. In the Browning-Ferris decision, if one entity is partly responsible for a violation, say failure to pay overtime, there would be a joint employer for the purpose of making sure that the person is paid the overtime. Under this bill, apparently, if the control is indirect, you indirectly prohibit the paying of overtime. When the claim comes, if it's indirect, then somebody else will be responsible for the overtime. So I guess I would agree with the gentleman who says all the worker protections are maintained. The problem is you've eliminated the possibility that somebody might be responsible. I would ask the gentleman, in terms of a legislative interpretation, under the original bill, if you were not, did you not exercise control over all hiring employees, discharging employees, determining individual employee rates of pay and benefits, day-to-day supervision, assigning work, schedules, positions, and tasks, and administering employee discipline. If you didn't do all 9, if you did 8 of them, but you had hiring and firing, but you didn't do scheduling, then you weren't an employer. And it was possible under the original bill that nobody was an employer, because one did 8, one did 1, nobody did all 9, and nobody's an employer. You get an overtime violation. And yes, you're owed overtime, except nobody owes it to you. Under the amendment of nature of a substitute, you have such as and or towards the end. Is it the interpretation that any one of these, if you do any one of these, you're an employer, or do you need all 9 of employer? It says terms and conditions, plural, so I assume it's more than one. Exactly how many of these examples would you have to actually control before you are deemed an employer? And I'd yield to the gentleman to respond.
Thank you, Mr. Scott, and I appreciate the opportunity to make that clarification. I do not think that the prior language did the things that some of the people were saying previously. But in order to make it absolutely clear, the amendment in the nature of a substitute makes it, I think, doubly so clear. So the list of things that you see there, first of all, the standard is if such person directly, actually, and immediately, and not in a limited and routine manner, exercises significant control over essential terms and conditions of employment. And that's the standard. So that's what's prescriptive. Then it says, and the following things are illustrative, not prescriptive. It says, such as hiring employees, discharging employees, determining individual employee rates of pay and benefits, et cetera. And then it gets to the end, it says, or administering employee discipline. Any lawyer reading that would know that you don't have to have all of those if you use the word or. And such as would tell anybody that this is an illustrative set of things and not a prescriptive. Now, this simply returns what the situation was prior to Browning-Ferris, because courts have already used these sorts of things to determine under the sort of prescriptive language we got here who is and who is not an employer. So I would say that what we've done with the amendment in nature of a substitute is take care of the concerns that we heard from the other side by making very explicit what I thought was pretty clear before, but certainly making it explicit in a way that the courts will know how they can go back to the way they were determining these things prior to Browning-Ferris. And I yield back.
Reclaiming my time, I'd like to repose the question in a different way. If you have direct control over hiring and discharging but nothing else, would you be or would you not be a joint employer? To the gentleman.
I can't answer that question because that would have to be determined by an administrative law judge or the NLRB based upon the facts of each individual case. I don't think any lawyer, any practitioner can give you a hard and fast answer to that question.
Well, Madam Chair, reclaiming my time, I think we're right back where we started from. We don't know what it means. Whether you're an employer or joint employer or not, you could be hiring and discharging. You might be an employer. You might not be an employer. And we're trying to figure out who a joint employer is, and this just adds, I think, more confusion. At least you knew you had to do all 9 under the original bill. We can't get an answer to how many of these things you have to do before you are a joint employer. So there you are.
Thank you, Mr. Scott. Mr. Wilson, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. I'm grateful to Chairwoman Virginia Fox and Subcommittee Chairman Bradley Byrne and Tim Wahlberg for their leadership on this important issue. For over 30 years, employers and employees have relied on a dependable definition of joint employer as, quote, actual, direct, and immediate, end of quote. However, a recent decision by the abusive NLRB has illogically expanded this definition to companies sharing only indirect or potential control causing inconsistency and uncertainty threatening jobs. I have met with various business leaders throughout the 2nd Congressional District of South Carolina who have expressed deep concern about the negative impact this overreaching, burdensome regulation will have on franchisees, contractors, and other local businesses, reducing job creation in such vital industries as hospitality, which we appreciate for providing entry opportunities for fulfilling lives. Today, this committee moves forward on a common-sense solution that would codify the definition of a joint employer under the National Labor Relations Act and the Fair Labor Standard Act to require direct and immediate control over employment. This would restore the consistent standard that businesses and workers have relied on for decades to promote new jobs. I am grateful to be an original co-sponsor of H.R. 3441, the Save Local Business Act, which is being improved by the Byrne Amendment, and I urge swift passage of this crucial piece of legislation to protect local businesses, workers, and job creation. I yield back the balance of my time.
Thank you, Mr. Wilson. Does any member seek recognition on the substitute?
Madam Chair, I have an amendment at the desk.
I believe Mr. Polis wishes to speak on the substitute amendment. Mr. Norwood.
Thank you, Madam Chair. Yes, I did want to speak on the substitute amendment. I wanted to talk about the underlying bill and the amendment. Really, there's a basic concept in common sense that we try to enshrine in law in various areas. If something looks like a duck and quacks like a duck, it is a duck. And what this bill would essentially do is make it too easy to disguise somebody that really is an employee. All an employer would have to do is outsource one of the 9 listed terms and conditions of employment to another entity and evade all responsibility to pay workers owed wages. There's ramifications for the definition of what an employee is well beyond labor law. It also affects tax law and other areas of employment law. If we truly give some fly-by-night or virtual company effective control over determining a worker's schedule, and a company can play the cruel game of not it, it's not me, with their workers, even though there's no there with regard to the nominal employer that would be defined for purposes of labor law under this bill. And because an employer must exert control directly, actually, and immediately under the bill, and I would say it's all three, directly and actually and immediately under the bill, an entity could convey employment directions through an intermediary or institute a delay so that the control was not immediate, whatever that means. A day later, an hour later, scheduling a week ahead, 2 weeks ahead. And just like that, the employer basically calls the shots. The people working for the illusion of a contractor and a nominal employer bears none of the responsibility back to the company and foists all of the responsibilities onto the nominal contractor, even though the employer is calling the shots. That standard of directly, actually, and immediately is a very easy one to get around, even though, in effect, the employee looks like an employee, is directed like an employee, and frankly is an employee. So this bill is not in any way, shape, or form a bill to save local businesses. It's a bill to make it easier for employers to cheat workers out of pay by bringing in fake contractors. And I've been in business. I've used contractors. I've had employees. We know what contractors are. We know what employees are. This bill further blends those lines and actually worsens the situation for many employees by actually encouraging employers to go with pseudo-contractors instead of taking on the responsibilities of employments themselves. I think there's a better way. I'll have an amendment to the bill later that I'll talk about some other ideas, and I urge my colleagues to oppose this bill, and I yield back.
Thank you, Mr. Polis. Anyone else who wishes to speak on the substitute amendment? We'll now move to considering amendments to the substitute. And I believe, Mr. Norcross, you have an amendment you'd
Yeah,
like to offer.
I have an amendment at the desk.
Would the clerk please distribute the amendment? Dr. Rowe is recognized.
Madam Chairwoman, I reserve a point of order on the amendment.
Dr. Rowe reserves a point of order on the amendment. Mr. Norcross, you're recognized for 5 minutes to speak on the amendment.
Thank you, Madam Chair. Today, we are considering a solution in search of a problem. This bill creates a new definition of joint employer, replacing the long-settled law with chaos and uncertainty. My amendment instead enacts traditional joint employer standard, which is rooted in hundreds of years of common law and was relied upon by the NLRB for decades prior to 1984. This is not new. We're suggesting we just go back to where we were. It strikes the bill's effect on the Fair Labor Standards Act in order to protect workers from wage theft and overtime theft. This simple amendment ensures that principles of democracy continue to be upheld in the workplace, protecting workers' freedom of association and their right to seek justice if they are treated unfairly in violation of the law. There are 800,000 franchises in the United States, and not one has ever been found to be a joint employer. Not one in 800,000. American workers suffer more than $250 million of wage theft each year. This bill exacerbates that problem and enables corporations to keep wages low, evading personal responsibility by subcontracting their work. They subcontract their conscience to put profits over people. At the end of the day, this bill does nothing to give a helping hand to those hardworking Americans we represent fighting to join the middle class. I have a letter from the Teamsters opposing this bill that I'd like to enter into the record.
Without exception.
Thank you. This union organized the workers at the Browning-Farris case that we've been talking about. This amendment relies on, and this letter describes what really is at stake for workers and their wages. This committee should be debating ideas that help hardworking Americans provide a better life for themselves and their family, like raising the minimum wage, providing comprehensive child care proposal, and improving safety on the job site. This does none of it. By the way, it's been 10 years since this Congress has even voted to raise the minimum wage. A decade. Those are some real things we can do. Rigging the rules against employees accomplishes absolutely nothing. My colleagues on the other side of the aisle talk about employees deserve better. Well, if they deserve better, raise the wages. If they employ and they deserve better, give them the dignity of retirement. Make the job site a little bit safer. Don't try to hurt the very employees that you count on to help grow your company and profits. I urge the committee to vote in favor of this amendment, and I reserve the balance of my time.
Thank you, Mr. Norcross. And the point of order is withdrawn. And we now recognize Subcommittee Chairman Tim Walberg of Michigan.
Thank you, Mr. Chairman. And I thank the gentleman from New Jersey for his concern about that. And we have points of difference, and this is one of those points of difference. See, I believe that this amendment is directly contrary to the purpose of H.R. 3441, which restores the common sense requirement of direct, actual, and immediate control over essential terms and conditions of employment. Unions and trial lawyers have long sought a broader definition of joint employer, but make no mistake, it comes at the cost of jobs, the cost of economic opportunity. The board's decision in BFI and Fourth Circuit's decisions, Salinas, have caused uncertainty for small business owners all across the country who fear that they will lose the independence and control they work so hard to attain. Both decisions drastically expand the definition of joint employer. H.R. 3441 will make clear that to be considered a joint employer, an employer must have actual, direct, and immediate control over employees, essential terms and conditions of employment. The Save Local Businesses Act rolls back these harmful decisions that will lead to fewer jobs, threaten the livelihoods of countless small business owners and their workers, and make it harder for individuals to pursue the American dream. I believe that to the bottom of my heart. H.R. 3441 will restore established labor policy that has long served the best interests of consumers, workers, and employers. So, in the end, I ask my colleagues to vote no on this amendment, as it would only hurt small businesses and their employees. And, Mr. Chairman, I yield back.
Thank you, Chairman Wahlberg. And we now proceed to Congresswoman Susan Davis.
Reclaim the balance of my time.
You may.
Thank you. Well, I appreciate the remarks, but we have to actually consider what reality
Would the
is.
gentleman suspend for a second? You had your time, we're going back and forth. You'll get time, you can get time later. Okay.
I now recognize Congresswoman Susan Davis of California.
Thank you, Mr. Chair, and I want to thank my colleague, Mr. Norcross, for bringing this amendment forward. Yeah, this bill has more flaws than I care to list, but one of my biggest concerns is that it would make it harder for many workers to bring Equal Pay Act claims. This bill has broad implications, it's pretty clear, not only impacting wage and hour laws, but also equal pay laws. It was more than 50 years ago that President Kennedy signed the Equal Pay Act into law, making it illegal to pay unequal wages to men and women who perform substantially equal work. Because the Equal Protection Act is part of the FLSA, the same joint employer standards apply. This bill narrows the definition of who can be considered a joint employer, reversing decades of precedent set under the FLSA, and in doing so, it impacts workers' ability to bring equal pay claims under the EPA. What we want to do is help workers secure remedies when there is wage theft, not go in the other direction. Unfortunately, as we all know, there is still a pay gap in this country, and we need to focus on strengthening protections against unequal pay for unequal work. We should instead be considering the Paycheck Fairness Act rather than this bill today. Thank you, Mr. Chairman.
Thank you, Ms. Davis. We now proceed to Congressman Sablan.
Thank you very much, Mr. Chairman. Mr. Chairman, let me begin by saying, extending my support of the Norcross Amendment to H.R. 3441. The right of workers to collectively bargain under the National Labor Relations Act is essential for them to secure fair wages and working conditions. For workers to be able to bargain effectively, they have to have someone across the table to bargain with, the party or parties that control their hours, wages, benefits, and work environment. Negotiation with themselves would be a futile exercise. H.R. 3441 would eviscerate the definition of an employer to the point that not only might the true employer not have to come to the table, but it might be possible that no employer would have to come to the table. Under the Norcross Amendment, which restores the traditional standard for determining joint employment and relies on principles of agency, businesses that have a common law employment relationship with its employees will not be able to escape its lawful bargaining obligations. It requires that an employer that possesses sufficient control over the essential terms and conditions of employment to be accountable to its workers under the law. It means that an employer cannot simply outsource one of the H.R. 3449 listed terms of employment to another entity and avoid the responsibility to collectively bargain with its employees. The amendment provides a clear pathway to the franchisors who do not want to be deemed an employer under the NLRA and become involved in local labor relations. Franchisors who seek only to maintain brand standards and product quality will be able to avail themselves of the unique franchise model to fund an expansion of its business, while only those who maintain sufficient control over the essential terms and conditions of their franchisees, employees will risk being deemed an employer under the National Labor Relations Act. The recent NLRB General Counsel determination in Freshie, where a restaurant franchisor with over 100 stores was not held to be a joint employer because its control over its franchisees was generally limited to brand standards and food quality and did not exercise control of the terms and conditions of employment of its franchisees' employees, illustrates the pathway available to franchisors under this definition. I urge my colleagues to support the Norcross amendment. Mr. Chairman, I yield back my time.
Thank you, Mr. Sablon. We now proceed to Congressman Takano of California.
Thank you. Thank you, Mr. Chairman. I strongly support Mr. Norcross's amendment to maintain the current definition of joint employment under the NLRA and to remove provisions changing joint employment under the FLSA. More and more employees are working for a company whose name is not on the front of their office building. Instead of hiring employees directly, companies are renting employees from staffing agencies and then evading responsibility for upholding the rights of those workers, even though they profit from their work. For decades, joint employment standards have ensured workers can hold employers accountable for violating wage and hour laws or refusing to collectively bargain. This bill represents a significant and dangerous break from that precedent. It denies millions of workers the right to hold their employers accountable for wage theft and undermines their ability to have the responsible parties at the table in order to collectively bargain for better wages. Labor and employment laws have long held that where more than one entity controls the terms and conditions of employment, an employee may have multiple employers. The definition of joint employment is much broader under the FLSA than the NLRA. The NLRA definition centers on the employer's control or right to control the terms of employment. But the FLSA definition relies on the economic relationship between the employee and potential employer. Now, these two standards have important and separate roles in protecting the rights of American workers and combating the extreme and crippling inequality in our economy. The so-called Save Local Business Act erases those standards and replaces them with one definition which is so narrow that very few large corporations could be held accountable if their contractors violate workplace laws. In doing so, this bill would seriously undermine worker protections and create a roadmap for unscrupulous employers to evade their obligations under both the FLSA and the NLRA. Now, this debate is not about hypotheticals or semantics. These definitions have a real impact on the lives of workers who lack leverage in their workplace. And I've seen firsthand how the law benefited nearly 1,700 low-wage workers at a Walmart warehouse in my own district who were victims of wage theft. Without joint employment protections, these workers would have had no remedy. The subcontractors were undercapitalized and couldn't pay them the wages that they were owed. But because the lead companies, Walmart and Schneider Logistics, retained control over many of the conditions of employment, these workers had a remedy. The case was eventually settled for more than $22 million. The proposed legislation would also undermine our efforts to prevent child labor. The FLSA's joint employer definition was specifically designed to punish employers who attempt to shield themselves from liability for child labor violations. We have not yet completely eradicated oppressive child labor in our society and need to maintain the strong employer standard under the FLSA in order to do so. The Department of Labor recently issued a report which found that in the United States last year, there were 633 cases where child labor law violations were found. That's 633 too many. And a bill that makes it easier for businesses to avoid laws that protect children is unacceptable. Mr. Norcross's amendment reinstates the existing joint employment standards by ensuring that the joint employer standard under the NLRA is the common law standard for joint employment, and by striking this bill's change to the FLSA. Frankly, the changes to the FLSA definition have no place in this bill to begin with. The majority's argument that this bill is about protecting franchisor-franchisee relationships is contradicted by a simple fact. There is not a single case where a franchisor and a franchisee have found to be joint employers under the FLSA. Changing the definition of joint employer under the FLSA is a solution in search of a problem. I urge my colleagues to support Mr. Norcross's amendment to reinstate current joint employment standards into this bill. Thank you, Mr. Chairman, and I yield back the remainder of my time.
And thank you, Mr. Takano. We now proceed to Congressman Paul Mitchell of Michigan.
Thank you, Mr. Chair. Two comments, and I assure you I'll be briefer than 5 minutes. First, my colleague on the other side of the aisle highlighted really the underlying intent of this amendment. That is essentially to gut the intent of this bill. We should at least be honest about it rather than try to dress it up or paint horror stories. The other thing this bill does is it reflects the fundamental debate that's going on in this chamber, in Congress, and across this nation. What is the role of Congress versus courts, independent boards, and bureaucrats? Ultimately, it's the role of this Congress and the people to determine what the laws are. It is our role to write laws and correct the misinterpretation or activism of the courts, independent boards, and the bureaucrats that think they know better than the people that were elected to represent our districts. That's what this bill does. And frankly, we're restating or reinvigorating the role of Congress to determine what the law says rather than abdicating that to a court system, to bureaucrats, NLRB, and various other boards that think they operate independently. I'll support the bill, and I suggest we move on to things that are equally important. Thank you. I yield back.
Thank you, Congressman Mitchell. We now proceed to Congresswoman Alma Adams of North Carolina.
Thank you, Mr. Chair. I oppose H.R. 3441, and I do support Mr. Norcross's amendment to enshrine the common law joint employer standard into the statute. H.R. 3441 has been pro-offered by the majority as a way to create certainty for employers in the joint employment context. Instead, this bill does nothing but create uncertainty for millions of women and children for whom our labor laws were intended to protect. When President Kennedy signed the Equal Pay Act in 1963, he remarked how our economy depended upon women in the labor force. In 1963, 1 out of 3 workers were women. Today, that number is almost 1 in 2. Women today buy more goods than men. We own more businesses than men. We earn more degrees than men. So it stands to reason that women are more important than ever before in preserving strong economic progress. And with that being the case, why would the majority hinder that progress by amending the Fair Labor Standards Act in this way? The facts show that H.R. 3441 would make it more difficult for women in subcontracted or franchise jobs to bring suit against employers who would violate their right to equal pay for equal work. This is devastating for women who've seen their pay gap with men remain unchanged in 10 years. And I wish I could say that was all, but H.R. 3441 would not only harm women, but it would potentially harm the entire family unit. Our child labor laws are some of the most treasured of our code because they ensure the safety and well-being of our most important resource, our children. But under HR 3441, a teenage worker may be subject to violations of their labor rights without any recourse. And this is especially true as many teenagers work in many of the subcontracted and franchise occupations that HR 3441 will affect, such as agricultural work and the fast food industry. Mr. Chair, we've had countless hearings and markups about how terrible the Browning-Ferris decision is, despite the fact that all it did was reinstate the standard that was law since the Great Depression. And so it's disappointing that these proceedings have resolved themselves in HR 3441, a threat to the economic well-being of millions of Americans, and a disservice to the memories of all of those who fought for fair and humane workplace protections. And instead of marking up this misguided bill, it would be great if we spent some time addressing the concerns that my colleagues and I have cited today. So I joined the call of my colleagues who've asked for consideration of the Paycheck Fairness Act to finally make the principle of pay equity a reality. And I urge support for Mr. Norcross's amendment, and I yield back the balance of my time.
Thank you, Congresswoman Adams. We now proceed to Congressman Adriano Espaillat of New York.
Thank you, Chairman, for the opportunity to speak. I ask unanimous consent to enter into the record a statement from the Farm Workers Justice outlining the importance and history of the joint employment standards. Mr. Chairman, this bill strikes at the fundamental definition of joint employer to detach responsibility of our fair labor laws. As my colleagues have highlighted, there are numerous unintended consequences that this bill signifies. In this period, I want to highlight a segment of our economy that will be devastated by this change in the definition of joint employer, and is often overlooked. That is the segment of migrant and seasonal agricultural workers. Migrant and seasonal agricultural workers have protections that guarantee wages, health, safety, and record keeping. This guarantee is the Migrant and Seasonal Agricultural Protection Act, which is built on the foundation of the Fair Labor and Standards Act that stipulate that joint employment under Fair Labor Standards Act is joint employment under the MSPA. By changing the definition of joint employer, this may threaten basic elements of employment such as hourly wage, working condition, reasonable and safe housing, and transportation. Low-income hourly and temporary workers would be left to scramble. They may fall victim to an employer seeking to take advantage of their own financial benefit. We all know that many migrant and seasonal workers are undocumented persons whose hard work and labor are an integral part of our economy. There are many abuses of these undocumented workers by farms and farm labor contractors. Farm labor contractors are intermediaries who must adhere to the Migrant and Seasonal Agricultural Worker Protection Act. Again, the importance of the joint employer standard here makes sure that workers who are recruited, hired, and supervised or transported must provide a lawful standard of work. This standard is not dissimilar to one that every member of Congress as an elected representative knows and expects. Changing the joint employer definition as envisioned under this bill means that farm workers can be paid less than minimum wage, housed in unsafe conditions, and perform dangerous work, but have no legal recourse against the farm labor contractor or the farm operator. Reduced wages or non-payment of wages are violations that we find in many cases brought by migrant and seasonal workers. Farm workers make little money compared to the value of their very hard work. They deserve a raise. I want to encourage all members to support Congresswoman Wilson's amendment that will ensure fair and basic compensation for all workers. In a world where HR 3441 is the law, there is no joint employer. That is a jarring message to the hardworking men and women of our economy, and in total opposition to the Migrant and Seasonal Agricultural Worker Protection Act, whose goal is to reverse the historical pattern of abuse and exploitation of migrant and seasonal farm workers. This bill will fracture and harm our workforce. I believe that Congressman Norcross' amendment can bring us back from this dangerous precipice. I want to thank the gentleman from New Jersey for offering this necessary amendment and urge all members to support it. Thank you, Mr. Chairman.
Thank
I
you,
yield back.
Congressman Espaillat. We now proceed to Ranking Member Bobby Scott.
Thank you, Mr. Chairman. Mr. Chairman, we've heard a lot about what the purpose of this bill is. I don't know exactly what the purpose is, but the reading of it shows that if this amendment is not adopted, an employer who sets wages indirectly cannot be required to negotiate with unions under the National Labor Relations Act. Without the amendment, unions can be at the table and be told by the people they're negotiating with that they have been indirectly directed not to increase wages. And the person with the funding source said you can't increase wages. Well, you can't have meaningful negotiations if that's what's at the other side of the table. In fact, that's exactly what's happening under Browning-Ferris. Lead Point was limited in what it could pay in wages. And the NLRB said, we're going to have meaningful collective bargaining, you've got to get BFI at the table, because they're controlling the wages. And so, I don't know what the purpose is, but if this amendment doesn't pass, you'll have people who are at the table who cannot meaningfully bargain. And so we would hope that those who are who control the wages can actually be at the table to negotiate wages. I'd like to ask unanimous consent that a letter in opposition to the bill from the Economic Policy Institute be entered into the record.
No objection shall be admitted.
And I yield back.
Thank you, Congressman Scott. We now proceed to Chairman Bradley Byrne.
Thank you, Mr. Chairman. I want to make sure that we're very clear about what the gentleman's amendment does. It would codify BFI. BFI changed the law. It'd be very clear. This is what BFI did, was change what was the interpretation of the law for decades. And it was a common sense, clear standard that everyone understood. So we're not putting something new into place with the underlying bill. BFI put something new into place, and this amendment would codify BFI. And we heard testimony after testimony after testimony in this committee from people who've been hurt by the interpretation of BFI. Now, let me make sure I address this issue about litigation or potential litigation against franchisees. Here's the game. The game is they're looking for a decision in the McDonald's case, and once they've got that decision, they use that as the precedent. You have a flood of litigation against franchisees. That's the game. We all know it. Let's just get it out there right now. And what the labor unions that are putting out these talking points that I'm hearing repeated out here today, the labor unions want to have BFI. It's to help them. It's not to help workers. It's not to help employers. It's to help the big labor unions. So codifying BFI hurts workers. Codifying BFI hurts these small businesses that we heard before the committee. And this idea that there was some common law of what a joint employer standard was prior to the National Labor Relations Act or the Wage and Hour Law is totally bogus. There's never been a definition of joint employer under the principle of the doctrine of principal and agent. Never. Now, I thought that when I was hearing the testimony here a couple of weeks ago, but I got the smart legal staff here to go look it up and make sure this old lawyer hadn't forgotten something. There wasn't. That is a bogus argument. The reason you've got these two statutes is there was no protection in common law for employees. You needed the statutes passed by Congress to give them the protections. And Congress, but when it sets a statute, can set what the definition of the terms in the statute are. That's plain legislation. It shouldn't be up to courts. It certainly shouldn't be up to unlettered bureaucrats to do that. We should do that. Now, my bill does not change one iota of the definition of employer. It provides a clear statutory definition for what is and what is not a joint employer. Now, I couldn't respond to Mr. Scott's inquiry before about a specific case because that's not the way it works. If you've got a specific case with specific facts, it goes to an administrative law judge. And the administrative law judge hears all the facts and then takes the law and applies it to the facts. And if we make the law explicit in the statute, that helps an administrative law judge do his job, and it helps the parties before they get there know what the outcome's likely to be. Now, there's not one single thing in this bill that changes any of the substantive provisions of the Equal Pay Act. Not one. Every protection that someone has under the Equal Pay Act would be there the day after we pass this law. It does not change any of our child labor laws, not one single one. All the protections that are under those laws would be there the day after we pass this law. And it does not change the law on migrant and seasonal agricultural workers. It doesn't have any effect on that. I know those are the talking points of the unions, because the unions are looking for some way to protect BFI, but not a single one of those is true. It is totally bogus. So let's get back to what we're here today to do. Mr. Scott asked, what is the purpose of the legislation? The purpose of the legislation is to give a clear and workable definition of joint employer to help workers and to help job creators. We heard testimony about how it's hurting both of them in front of this committee on several occasions. The bill clearly takes care of those problems, and the amendment offered by Mr. Norcross would take us back to this thing that got us here in the first place. So I'd urge everyone to vote no on the Norcross amendment, and I yield back.
Thank you, Chairman Byrne. And are there any further members who would like to speak on the amendment? Hearing none, we shall now proceed with the question of the amendment. Calling the question, those in favor vote aye. Aye. Those opposed, no, vote no. No. The opinion of the chair, the noes have it, and the amendment is not agreed to.
That's a recorded vote.
And by Committee Rule 13B, the vote shall be postponed. And we shall proceed to the next amendment. And we proceed to Congresswoman Marcia Fudge.
Thank you very much, Mr. Chairman. I too join with those who offer their thoughts and prayers for Las Vegas. I certainly hope that there comes a point when we can do more than offer our thoughts and prayers. Maybe we can do something for a change.
Congresswoman, we need 1 second to distribute the amendment.
Thank you.
Dr. Rowe, Chairman Rowe.
Mr. Chairman, I reserve a point of order on the amendment.
The clerk shall distribute the amendment. And Congressman Fudge, please proceed.
Thank you, Mr. Chairman. As I was saying, maybe we can finally do something as a Congress. Maybe we can ban the kind of equipment that modifies semi-automatic weapons and makes them automatic. Maybe what we can do is limit the clip sizes that people have. Maybe we can just be sure that no one person has 47 weapons and thousands of rounds of ammunition. I support the Second Amendment, but I also support common sense. I support protecting people from these kinds of people. Maybe what we can finally do is protect the children that we care about by authorizing the funding for the Children's Health Insurance Program. Maybe we can go back to funding community health centers. At some point, Mr. Chairman, we need for the American people to be proud of what we do and not what we say. Maybe we'll do something one day. I do have an amendment. The bill before us today is a substantial rewrite of the joint employer standard, altering critical worker protection laws and limiting worker rights. Under the Save Our Local Business Act, workers cannot hold employers liable for wage theft, for overtime violations, safety hazards, or unfair labor practices. Union members cannot negotiate with companies controlling terms and conditions of employment. The amendment I am offering would help preserve these rights by exempting disputes over who is the true employer from any type of pre-hire or mandatory arbitration agreement.
My Republican colleagues argue that if an employer violates the National Labor Relations Act or the Fair Labor Standards Act, employees can simply bring a claim to the NLRB or file suit. Last week, the Economic Policy Institute released a study finding that half of all non-union employees are subject to mandatory arbitration whenever they have a work-related dispute. Just this Monday, the Supreme Court heard oral arguments on whether companies can require workers to waive their rights to resolve disputes under the NLRA through class actions or collective proceedings. If the Supreme Court rules against the employees and H.R. 3441 passes as written, companies could require that employees arbitrate individually over claims when they want to raise collectively those claims. And those claims would be solely under the determination and control of an arbitrator of the employer's choosing. Employers could very easily insulate themselves from legal responsibility and pass those liabilities on to the smaller contractors this bill claims to want to save. When workers exercise their right to form a union, it is crucial they be able to negotiate with all parties controlling the work relationship. The bill's language is so ambiguous, it may even leave employees without any employer. If two companies claim not to be employers and both fail to meet the bill's narrow definition of a joint employer, employees may be left with no one to hold accountable. Each time we discuss joint employer, my colleagues say we must act quickly to fix an ambiguous standard. The law is not ambiguous. In fact, my colleagues have demonstrated a very clear understanding of the law. The truth is they just don't like the businesses being held responsible as actual employers. Income inequality is skyrocketing while corporate profits are at an all-time high. The average worker hasn't received a meaningful raise in years. Letting employers avoid liability for wage theft and denying workers their right to collectively bargain would only exacerbate wage stagnation. Rather than attacking workers' rights, we should focus on raising wages and improving working conditions for all Americans. My amendment would simply protect access to the court system and halt the rapid advancement of mandatory arbitration. Workers should not be forced to choose between a paycheck and their legal rights. I urge my colleagues to protect collective bargaining and access to our judicial system, and to vote yes on my amendment. Mr. Chairman, I yield back.
Thank you, Councilwoman Fudge. The point of order is withdrawn, and we now proceed to Chairman Bradley Byrne.
Thank you, Mr. Chairman. This is another amendment for the big unions and for the trial lawyers. It is not for the workers of the United States of America. Arbitration is frequently better for workers than going to court. Let me explain why. Arbitration can get you a much quicker result. Sometimes lawsuits take a very long time to get to resolution. You can get to an arbitration decision very quickly. Secondly, employees often get better results in terms of the actual remedy by going through arbitration than by going to court. Judges in courts are very much limited by legal precedent and legal procedures and even evidentiary procedures. An arbitrator has almost unfettered decision-making ability and can get to the equities of the case. I was a management lawyer. I never, ever recommended to my management clients—
Will the gentleman
they put
yield?
arbitration. No, ma'am, I'm going to finish what I'm saying. I never, ever recommended that we put an arbitration provision in there because I felt like the employer actually was better off without arbitration. And remember, you cannot appeal an arbitration award. If you get an award you think is wrong, you're stuck with it. And I can tell you, in many cases, it was a lot better for my management clients to not have an arbitration provision. So if you really want to look out for the workers of America, let them have the opportunity of an arbitration. There are ways to look at the arbitration after the fact, but by getting them a quicker result and giving them the ability to argue the equities in front of an arbitrator that's not limited like a lot of judges are, they're often better off. This amendment is nothing more than a distraction from the underlying bill. The bill preserves protections for workers under the National Labor Relations Act and the Fair Labor Standards Act. And the remedies are provided for them in current law. This bill does nothing to change or diminish those remedies, nor does it have any effect on arbitration agreements. What this bill does do is restore a common sense joint employer standard, and this amendment is unnecessary, and I oppose it, and I urge my colleagues on the committee to oppose it as well and vote no, and I yield back.
Thank you, Chairman Byrne. We now proceed to Ranking Member Bobby Scott.
Thank you. I yield to the gentlelady from
Ohio.
Ohio.
I thank the gentleman for yielding. I just want to just take 30 seconds to just be clear that Mr. Byrne, that he is not the only lawyer in this room. We understand the difference between arbitration and going to court. And I think that your tone is condescending to the fact that we do understand the difference. I yield back. Thank you. I yield back the gentleman's time.
Thank you. Mr. Chair, this amendment just says the provisions of the bill will not be subject to the terms of a pre-dispute arbitration agreement. The Supreme Court considered this issue just a couple of days ago, where the question was whether or not the pre-dispute arbitration agreement that did not allow for collective action was legal in the NLRA. That a lot of issues, like a failure to pay overtime, unless you can bring some group action, is a waste of time. It costs you thousands of dollars to bring a law case, and and thousands of dollars to bring a legal action. If you have thousands of people all having their overtime unpaid, unless they can come in together, no individual can bring a case. It's not worth it for any individual, although you may have a couple of $1,000s you've not been paid. If you have to bring each individual case, nobody's going to bring a case. If you can bring it collectively, then you can get compensation. Under this bill, you don't know who you can bring it to, and you may be stuck with the arbitration. I would hope that we would adopt this amendment, which would say that you're not subject to the terms of a pre-dispute arbitration agreement, sticking you with arbitration without the ability to, many times without the ability to do a collective action, and essentially have your rights, although your rights are protected, they're right there. You just can't, bring an action because you can't afford it. That's not protecting you've got the protection on the books in writing, but you can't, it's just a waste of time to bring the action. I think the studies have shown that employees much better off in federal or state court than they are in arbitration anyway, because it's easy to stack the arbitration panels. I would hope that we'd adopt the amendment, and I yield back. Wait a minute, and before I yield back, I'd like to enter into the record a op-ed from the NAACP Legal Defense Fund.
Without objection.
Thank you. I yield back.
Does any member wish to be recognized? I believe then we are ready to call the question on the amendment. Those in favor, please say aye. Aye. Those opposed, no. 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 In the opinion of the chair, the noes have it, and the amendment is not agreed to. The gentleman has requested a recorded vote. Committee Rule 13B allows postponed votes. Mr. Scott, you're recognized.
Thank you. Madam Chair, I have an amendment at the desk.
Would the clerk please distribute the amendment? Dr. Rowe, you're recognized.
Thank you, Madam Chairwoman. I reserve a point of order on the amendment.
Dr. Rowe reserves point of order. Mr. Scott, you're recognized for 5 minutes.
Thank you, Madam Chair. Madam Chair, as we discussed at the September 13th legislative hearing, H.R. 3441 is introduced, creates a bizarre circumstance where it is certainly foreseeable that employees would have no liable employer when the NLRB or the court finds a violation under either the NLRA or the Fair Labor Standards Act. You can find that an employee was not paid overtime, and then look up, and there's no employer that owes the money. The amendment in nature substitute tries to cure this problem with some limited changes, but we still can't get a straight answer on exactly who is an employer for some situations and whether or not it's possible that no employer can be identified. For that reason, I'm offering this amendment to clarify that when there are joint employers, but none of the employers are liable for a violation, then the changes in this bill do not apply. Under the original language of the bill, a company is not a joint employer unless it directly, actually, and immediately exercises significant control over each and every one of the 9 listed essential terms and conditions of employment. If one company controls some of the terms and another company controls the rest of them, then neither company would control all 9 terms of employment. And if an employee tries to bring a case against an employer, both of them can point the other way and say, it's not me because I'm not an employer under that definition. The amendment in nature of a substitute created further confusion because it said you had to have essential control over terms, plural, and conditions, plural, of employment, but it doesn't say how many terms and conditions each employer would have to satisfy in order to be liable. It says the word "and" at the end of the list and substitutes "or," but it still doesn't necessarily clarify the issue. We tried to get an answer on how many of these elements would have to be covered. How many elements, the direct employment, firing, scheduling, what is it, when is somebody an employer, when they're not? It means if you talk about essential and then list some examples, it is still possible that the entity must control all 9 terms in order to be liable. I don't know. But if you get to the point where nobody's liable, then this bill should not apply. Even if the courts or the National Labor Relations Board avoid the plain reading of the bill provides no guidance over exactly how many terms and conditions a party would need to control in order to be deemed an employer and avoid such liability. All, some, obviously, because you're plural, more than one. And if somebody is designated, if somebody finds that they've not been paid overtime, can it be possible that nobody owes them? This amendment just says, if you're in a situation where nobody is found to be an employer under the bill, then the bill doesn't apply. Somebody ought to owe you overtime. If the court has determined that you worked 50 hours, you're entitled to overtime, somebody owes it, and if under this bill nobody owes it, then the court can ignore the bill and find somebody owes you the overtime that you haven't been paid. I yield back.
Thank you, Mr. Scott. Dr. Rowe, you withdraw the
point of order.
Dr. Rowe withdraws the point of order. Mr. Byrne, you're recognized for 5 minutes.
Thank you, Madam Chair. I call this amendment the Immaculate Employment Amendment. Somehow you get to be an employee without having an employer. That's like getting to be a child without having a parent. It is logically impossible. I would say it's legally impossible. Remember what my bill does. It defines joint employer. It does not change the definition of employer. So there will always be an employer, just as there is under existing law today. We're simply statutorily codifying the definition of joint employer. Now, I do understand Mr. Scott's concerns about the prescriptive and then the illustrative language in the bill. Once again, the prescriptive language is what the court will follow. And the court will look to the illustrative elements, as courts always do. And in just about every employment law that I can think of, courts look at various factors. That's what they do. And they look at those factors with the prescriptive standard in front of them and apply those to the specific facts in front of them. We're actually giving clarity to a decision maker here, a judge, administrative law judge, National Labor Relations Board, where there is no clarity today, and it's clarity that helps everybody, but particularly the workers. But there's no unclear thing about this at all. Every employee in America has an employer, just like every child in America has a parent. You can't get to be an employee without having an employer. Someone is directly, actually, and immediately, and not in a limited and routine manner, exercising significant control over the essential terms and conditions of your employment, or you're not working. So I appreciate the gentleman's amendment, but I think it's totally unneeded, and in fact, I think it would cause some real problems for courts out there trying to apply this standard, and I would urge everybody on the committee to vote no on the amendment. I yield back.
Thank you, Mr. Byrne. Ms. Davis, you're recognized.
Thank you, Madam Chair, and I yield my time to the ranking member, Mr. Scott.
Gentleman from Virginia is recognized.
Thank you. Madam Chair, I would just say that if there's no chance that you could end up with no employer, then you shouldn't be afraid of this amendment. Fact of the matter is that under the original bill, the purpose of the amendment nature of a substitute, I assume, was to get away from the possibility under the original bill that there would be no employer. If you have determined that your overtime has not been paid, and you go in and you point to one entity and say, I haven't been paid overtime, they owe me the overtime, they go in and say, well, according to the bill, I'm not an employer. Then you say, well, you go to the other one. According to the bill, I'm not an employer either. Then what happens? You know, this amendment would fix that. Somebody would be liable. And if, I think it's clear under the amendment that it's possible that nobody has total direct control over the employment. It could be shared, and if it's shared, everybody gets to escape liability. I don't think that's fair to the employee, and if that is not a possibility, then the provisions of the amendment wouldn't make any difference. If it is a possibility, then the amendment fixes it. I yield back.
The gentlewoman yields back. Does anyone else wish to speak on this amendment? If not, then I'll call the question on the amendment. Those in favor vote aye.
Aye.
Those opposed vote no. No. In the opinion of the chair, the noes have it. The gentleman's amendment is not agreed to. The gentleman asked for a recorded vote. Committee Rule 13B allows postponed votes. We will now consider if there are other amendments to the substitute. Ms. Bonamici is recognized.
Thank you, Madam Chairwoman. I have an amendment at the desk.
The clerk will distribute the amendment.
Madam Chairwoman, I reserve a point of order on the amendment.
Dr. Rowe reserves a point of order on the amendment. Ms. Bonamici, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. I want to start by aligning myself with the ranking member's comments about how, even though I don't agree with this bill, I do appreciate regular order and that we are having the markup and the opportunity to express our concerns about the bill. Madam Chair, the bill before us today is predicated on the inaccurate premise that the National Labor Relations Board's Browning-Ferris Industries decision would adversely affect the franchisee-franchisor relationship. And I just want to review, because we've talked about it so much today, what happened in the Browning-Ferris case. The employer in question controlled the speed of the conveyor belt where the contractor's employees sorted materials, prohibited the contractor from raising wages above a specified cap without their permission, and determined shift times and the number of people on shifts. That's certainly not a wild departure from the prior law to hold that that was a joint employer. And suddenly it seems like there's this notion that the sky is falling, and franchising was flourishing before that decision, and it continues to flourish. As I've discussed in this committee many times, I represented franchisees when I was a lawyer, and certainly appreciate and understand the franchise model and the role of franchisees and franchisors. The argument that the traditional test for joint employer adversely affects franchising lacks merit. As we've heard Not only in the hearings, but in this markup today, there has not been a single case where a franchisor has been found to be a joint employer. In fact, instead of saving local businesses, which is what this particular bill purports to do, the way this is drafted, it would actually set up incentives that could harm franchisees. And it does that by empowering franchisors to direct their franchisees in matters of labor relations, while expressly insulating the franchisor from liability for violations of labor laws that might arise from that direction. So my amendment would simply require that if a franchisor directs the action of a franchisee and the action results in a violation of the law, the franchisor would be liable along with the franchisee. In other words, simply put, a franchisor would be considered a joint employer if the franchisor acts like a joint employer rather than like a franchisor. In fact, in a hearing on this issue, one of the witnesses, Professor Michael Harper, pointed out that this bill could actually have that unintended consequence and actually give franchisors greater control over franchisees than under current law. And Professor Harper noted that the bill as drafted would permit franchisors to indirectly control identity, work assignments, hours, wages, and working conditions of the employees of the franchisees without liability or responsibility in the courts or at the NLRB. That's certainly not what the franchisees who testified want. My amendment would fix this problem by subjecting franchisors to joint and several liability if a franchisee is acting at the direction of the franchisor, violates the National Labor Relations Act or the Fair Labor Standards Act. And I do want to clarify, because it was been brought up earlier, this particular bill amends both the National Labor Relations Act and the Fair Labor Standards Act. So this amendment would actually protect small businesses, the franchisees, promote the independence of franchisees, and cures the defect in the bill that insulates franchisors from liability for exercising that type of control that goes beyond their role as franchisors and exercising control over labor and employment relations. So I urge a yes vote and yield back.
Thank you, Ms. Bonamici. Mr. Byrne, you're recognized.
I appreciate the gentlewoman's amendment, but simply put, it's just not based in reality. Any franchise agreement or contract between two companies requiring one of those companies to violate the law would not be enforceable according to long-standing legal precedents. That's basic contract law 101. In fact, most franchise agreements contain the exact opposite language. They include a requirement that all applicable labor laws must be followed. But think it through even further. Such an action or agreement would likely, I would say more than likely, almost assuredly be evidence of a joint employer relationship under the bill in front of the committee. Think about it. If a franchisor requires a franchisee to pay its employees less than the Fair Labor Standards Act requires, that's direct, actual, and immediate control. That's going to turn the franchisor into a joint employer under the bill. So any franchisor that did what the gentlewoman says that her amendment's directed to, they would be pretty foolish to do so, because they would bring themselves squarely within the provisions of joint employer under the law. If a franchisor told a franchisee to violate the National Labor Relations Act by disciplining pro-union employees, that too would be direct, actual, and immediate control. So I don't really think that this amendment helps there. In fact, I think it creates a vague standard where remote or indirect actions by a franchisor could be used to find that they supposedly forced their franchisee to violate the law. Such a broad definition is just a backdoor to another BFI-like standard. This amendment is a solution in search of a problem, and I urge my colleagues to vote no, and I yield back.
Gentleman yields back. Mr. Scott, you're recognized.
Thank you, Madam Chair. Madam Chair, the BFI standard is that if you control the situation, you should be liable for that situation. This amendment just says if the franchisor directs a franchisee to take action, if it turns out that it's a violation, that they should be on the hook for fixing it because they caused it. You could have, it's not a question of violating the law. Some of it is just interpretation, like you direct them not to pay time when people come in and are changing into their uniforms. That could be compensable time, maybe it isn't. Well, when the decision is made, if you directed them not to pay it and we lose the case, then you should be on the hook to having to pay the overtime that's required. It just says that if you cause the problem, you ought to be responsible. I don't see what's so wrong with the amendment. I yield to the gentlelady from Washington. Oregon, I'm sorry, Oregon.
They're close,
Excuse me.
Mr. Ranking Member. Thank you, Ranking Member Scott, and I just wanted to respond to my colleague, Mr. Burns' comments that if, in fact, the franchisor is directing the franchisee in matters of labor and employment, and as Mr. Byrne acknowledged, that would make the franchisor a joint employer, then there should be no problem clarifying that by adopting this amendment. Thank you.
Gentleman from Virginia yields back. Does anyone else wish to speak on the amendment? If not, then the chair is prepared to call the question on the amendment. Those in favor vote aye. Aye. Those opposed vote no. No. In the opinion of the chair, the noes have it, and the gentlewoman's agreement is not agreed to, but the gentlewoman requests a recorded vote. Committee Rule 13B allows postponed votes. Do other members wish to offer amendments? Mr. Takano, you're recognized to offer an amendment.
Thank you, Madam Chair.
Dr. Rowe, Mr. Wilson will.
Madam Chairman, I reserve a point of order on the amendment.
Dr. Rowe reserves a point of order on the amendment. Clerk will distribute the amendment, and Mr. Takano, you're recognized for 5 minutes.
Thank you, Madam Chair, and I thank the chair for her acknowledging the terrible shooting that happened in Nevada. I just want to add for the record, Madam Chair, that there are 4 confirmed deaths of constituents of mine in Las Vegas. Angela Gomez, age 20, a Riverside Community College nursing student. Carrie Barnett, age 34. Disneyland cast member. Austin Davis, age 29, from my district. Thomas Allen Day, 54, a construction company worker. Madam Chair, I certainly hope that we will do more than offer our thoughts and prayers to the people who were killed and who are also injured. I certainly have had my share of tragedy coming from my district. Madam Chairwoman, the bill we are considering today in H.R. 3441 virtually destroys joint employment, an issue that comes up because of a violation of workplace rights. Wage theft happens when an employer fails to pay an employee minimum wage or overtime for all the hours that they've worked. Unfortunately, wage theft is a serious problem in our country. A recent study from the Economic Policy Institute found that in the 10 most populous states, 2.4 million workers lose $8 billion annually for minimum wage violations. This would amount to an average of $3,300 per year per employee working year-round. I mentioned the case earlier where 1,700 warehouse workers settled for more than $22 million in my congressional district because a subcontractor failed to pay them what they had earned. I ask unanimous consent to insert into the record a report from the Center for American Progress, which highlights why joint employer protection are as important today as when they were first created.
Without objection.
Given the prevalence of this problem, it is crucial that workers have the tools they need to fight back against wage theft. I ask my colleagues to think about this. If you were told that you were to be paid a certain amount, and when payday comes, your pay stub says something different, what would you do? You would go to your human resources person with your pay stub and ask about the discrepancy. Imagine, however, that you don't get a pay stub. You have no evidence for recourse. You also have no idea what deductions your employer makes. Employers' routine failure to provide pay stubs makes it extremely difficult to identify and prosecute wage violations. Despite laws in a majority of states requiring that employers provide some form of pay stubs to their workers, many workers never receive them. Federal law currently requires employers to keep certain wage records, but it does not obligate employers to share that information with employees through regular pay stubs. So unfortunately for workers, there is no federal guarantee that all workers receive a pay stub. My amendment will condition the application of this bill on workers receiving regular pay stubs to help them ascertain whether or not their employer is cheating them out of their hard-earned pay. Ensuring that all workers receive a pay stub is a critical tool that will empower workers to advocate for themselves. But in order to fully supply workers with the tools they need to combat wage theft, I believe that Congress needs to pass H.R. 3467, the Wage Theft Prevention and Wage Recovery Act. The right to a pay stub is just one of the important provisions in that bill. Now, I want to be clear. My amendment is by no means a fix to this fatally flawed bill. But with this amendment, at the very least, workers will be able to know if they're getting cheated out of their pay by their employers. I urge my colleagues to adopt this amendment, and I yield back the remainder of my time.
Thank you, Mr. Takano. Mr. Byrne, you're recognized for 5 minutes.
Thank you, Ms. Chairwoman. I appreciate my colleagues' interest in this issue. Let me say this very clearly. Wage theft is against the law. It's against the law. The amendment as a substitute doesn't change that one little bit. It doesn't even mention it. All this bill does is codify the definition of joint employer. It doesn't do anything to wage theft. The Fair Labor Standards Act already requires employers to maintain accurate records of hours worked and wages paid to employees. All records must be available for inspection or review by the Wage and Hour Administration. The bill doesn't change any of that. Workers will continue to have the same protections and rights they have under existing law. If my colleagues on the other side really want to help workers, we should focus on the task at hand, which is getting rid of this radical joint employer scheme that is hurting local businesses and their employees. So I would ask my colleagues for a no vote on this amendment and a yes vote on the underlying bill.
Gentleman yields back.
I yield back.
Gentleman yields back. Does anyone else? Mr. Scott, you're recognized.
Thank you, Madam Chair. Madam Chair, the gentleman is correct that wage theft is against the law, and this doesn't change it. What this bill does, what this amendment does, is let the person know that he's been ripped off, or have a way to calculate whether he's been ripped off. If all you get is a paycheck, you don't know whether you've been credited with the right number of hours. You don't know whether you've been credited with overtime. You don't know if the taxes have been properly taken out. You don't know anything. All you know is that you've got your paycheck, and the last thing you're going to do is insist that the employer open up his books so that you can inspect it. That's asking a lot of an employee. This is just simply, and a pay stub is fairly perfunctory, and most people would not recognize the fact that a lot of people don't get pay stubs. All they get is a paycheck. And that's why wage theft is a serious problem in the United States. I yield to the gentleman from California.
I want to be clear that my amendment in no way corrects the flaws of the underlying bill, but I cannot believe that the majority will not even concede to the notion that it's in this day and age that we don't have protections for workers to actually get a pay stub. I personally know of family members who've had to work extra quarters to earn their Social Security benefits because their employer did not pay their withholdings. They did not meet their obligations. It is against the law, but it is a very simple tool, a simple thing to be able to provide a paper trail to the employees, and federal law ought to cover that. And I don't understand why there is such a problem in accepting this amendment and empowering the many, many people in this country who work hard who may have employers who are shorting them their pay or may not be paying their Social Security taxes, and that employees can have a tool to hold their employers accountable.
Gentleman yields back. Does anyone else wish to speak on this amendment? If not, the chair is prepared to call the question on the amendment. Those in favor vote aye. Aye. Those opposed vote no. No. In the opinion of the chair, the noes have it. The gentleman from Virginia asked for a recorded vote. Committee Rule 13B allows postponed votes. It's now in order to move to the next amendment. And Mr. Polis, I believe.
I have an amendment to ask.
Amendment. Okay. The clerk will distribute the amendment. And
Madam Chair, I want to
Dr.
reserve a
Rowe?
point of order on the amendment.
Dr. Rowe reserves point of order on the amendment. Mr. Polis, you're recognized for 5 minutes.
Thank you, Madam Chair. My amendment very simply would rename H.R. 3441 a more appropriate and accurate name, the, quote, Wage Theft Immunity Act, end quote. Effectively, what this bill would do is create a roadmap for employers to prevent themselves from being held responsible for wage theft, outsourcing the risk of wage theft to others. As my colleagues have mentioned, under the Fair Labor Standards Act, covered workers are entitled to overtime pay for work they have already done. But for far too many workers, they continue to not see the wages that they're owed for the work that they have already done. According to a recent report from the Economic Policy Institute, 2.4 million workers in the 10 most populous states lost $8 billion annually for minimum wage violations alone. That's an average of $3,300 annually per year-round worker. Clearly, there's not enough incentive already for employers to follow our existing law. The last thing we need is yet another loophole to avoid the law. This bill makes things worse by effectively creating a guide for employers to protect themselves from the liability from stealing the work of their employees. Instead of spending time on legislation that undermines workers, we should be focusing on ways to enforce the laws, to give them meaning, to actually reduce wage theft, to lift up workers and roll back the very practices that promote wage theft. My bill, the Giving Workers a Fair Shot Act, would do exactly that. It would increase criminal and civil penalties for individuals who violate critical labor laws like the FLSA and OSHA. All too often, labor law violations are seen as a cost of doing business for employers. Instead of creating more loopholes for wage theft like the bill we're considering today, my bill would ensure workers receive their hard-earned pay. In addition to stronger enforcement of key labor laws, my bill lifts up workers in a number of other ways. It would ensure that no taxpayer funds are used for union-busting activities, like planning and implementing activities that deter employees from joining a union or threatening emails. My bill also updates the National Labor Relations Act definition of supervisor. Too often, workers are falsely reclassified as supervisors just so they can't join a bargaining unit. This more accurate definition would help prevent that sort of manipulation and increase the number of employees eligible to join a union. My Giving Workers a Fair Shot Act also empowers shareholders and creates new accountability for CEOs by preventing the CEO and chairman at publicly traded companies from being the same person. We'd all like to be our own boss, but that's not in the best interest of the company, the shareholders, or the employees. My bill also expands insider trading restrictions for executives to 1 year after they leave a company. And finally, all too often, employers drag their feet on a newly formed union's first contract for months, sometimes years, to avoid agreement, deliberately trying to prevent a newly certified union from receiving a first contract. My bill sets up a first contract arbitration system where the union or the employer has the option of seeking mediation if they feel one party is not responding adequately to a negotiation request. So instead of considering bills that allow wage theft to occur more often, we should be considering legislation like the Giving Workers a Fair Shot Act to actually address the real issues that workers and companies face. I urge my colleagues to support my amendment so the public can finally know what this bill actually does, giving wage theft immunity to some of the worst actors, making it easier for employers to cheat workers out of work they've already done by not paying them after the fact. I urge my colleagues to adopt the amendment, and I yield back the balance of my time.
The gentleman yields back. Mr. Byrne is recognized for 5 minutes.
Thank you, Madam Chairwoman. Let me say this very clearly again. Wage theft is against the law today. My bill does not change that one little bit. There are also procedures in place, I went through those previously, I won't go through them again, that allow for the review and enforcement of that law. This bill does not change that one little bit. The amendment's assumption is that businesses are looking for a way to evade their responsibilities to workers. I reject that assumption. The gentleman from Colorado, I know, did not look for ways to evade his responsibilities to his workers. As the amendment sponsor should also know, the underlying bill does not take away a single protection from a single worker in the United States of America. It only defines joint employer relationships. That's all it does. I also reject the idea that this bill is not about saving local businesses. This committee has heard from an entrepreneur who started his business in one of Baltimore's most struggling neighborhoods and helped turn it around after it was ravaged by rioters. We heard from another who helped New Orleans recover from Katrina. Both of them told us the importance of reining in an expanded joint employer scheme. This committee has also heard from immigrants and veterans who have used the franchise model to live the American dream. And all of them have told this committee the importance of returning to a common sense joint employer standard. We should not ignore their experiences and genuine concerns about the current joint employer standards. In fact, I think that the title for this bill is exactly accurate. And if you listen to those people who are here, small businesses that are doing great things in their communities, I think it's the least we can do for them. This bill is about saving local businesses. Main Street needs our help. Accordingly, I urge my colleagues to vote no against this absurd amendment and to support the underlying bill, and I yield back.
The gentleman yields back. Does anyone else wish to speak on this amendment? If not, then the chair is prepared to call the question on the amendment. Those in favor, please vote aye. Aye. Those opposed, vote no. No. In the opinion of the chair, the noes have it, and the gentleman's amendment is not agreed to. The gentleman from Virginia requests a recorded vote. Committee Rule 13B allows postponed votes. Are there other amendments? Ms. Wilson, you're recognized.
Thank you, Madam Chair. I have an amendment at the desk.
Okay. The gentlewoman has an amendment at the desk. Dr. Rowe, you're recognized.
Madam Chairwoman, I reserve a point of order on the amendment.
Dr. Rowe reserves a point of order. The clerk will distribute the amendment. Ms. Wilson, you're recognized for 5 minutes to explain the amendment.
Thank you, Madam Chair. Today, we're marking up a bill that will cripple workers' abilities to raise their wages. H.R. 3441 would undercut unions from being effective by preventing them from bargaining with all parties that control the terms and conditions of employment. It would also hamper workers' rights to seek legal recourse for wage theft. During this time of skyrocketing income inequality, this bill worsens that very problem. Instead of considering this malicious anti-worker, anti-union bill, we ought to bring up H.R. 15, the Raise the Wage Act, before this committee. H.R. 15 provides an important contrast between the Democratic Party's agenda for working families and the apparent agenda of the Republicans in Congress. The majority has used the 115th Congress to attempt to take away health care from millions of Americans, undermine civil rights enforcement, and advance legislation that would deny workers their hard-earned overtime pay. Too many Americans today cannot afford to buy a home, send their children to college, or save for retirement. It should not be this way. Indeed, American workers' productivity has led to tremendous economic growth, yet unfortunately the rules are written so that the economy delivers only for those at the very top. Here in Congress, we have the power and a responsibility to fix that by raising the federal minimum wage. Democrats are fighting for a long overdue raise that working people and families deserve. We will not back down. We will continue to stand up for workers' rights to earn a decent living. That is why today at this markup of this ill-conceived bill, I'm offering an amendment to strike the text of H.R. 3441 and replace it with H.R. 15, the Raise the Wage Act. It has been 10 long years since we last raised the minimum wage. And while 29 states have taken action to raise their wages above the federal minimum, in 21 states, minimum wage workers are still paid $7.25 an hour. This leaves a full-time, year-round worker with a dependent child living below the federal poverty threshold. Today's low-wage workers earn less per hour, adjusted for inflation, than their counterparts did 50 years ago, even though productivity has been doubled over that same time period. That is unacceptable. Raising the minimum wage to $15 an hour by 2014 will lift pay for nearly 30% of the American workforce and reverse the growing trend in income inequality between those at the top and everyone else. By 2024, workers in every region of the country will need a $15 minimum wage to cover the most basic cost of living, such as food, rent, and transportation. This amendment will ensure that all hardworking Americans, no matter where they live, can afford all the basic things necessary to have a decent life. Thank you, Madam Chair, and I yield back the balance of my time.
Thank you, Ms. Wilson. Dr. Rowe.
Madam Chair, I want to make a point of order that the amendment violates Clause 7 of House Rule 16.
Does any member wish to speak on the point of order by Dr. Rowe? The chair is prepared to rule. Germaneness is construed narrowly in order to support informed consideration of legislation. The chair finds the amendment is beyond the bill's subject matter. The bill narrowly amends the definition of employer to include joint employer. The amendment is a proposition on a subject different from that under consideration within the meaning of Clause 7 of Rule 16 of the House Rules. Therefore, the amendment is not germane. The point of order is sustained.
Madam Chair.
Madam Chair.
Yes, Ms. Wilson.
I respectfully appeal the ruling of the chair.
Madam Chairwoman, I move to table the appeal.
The gentleman from Tennessee has moved to table the appeal. The vote occurs on the motion to table. All those in favor of the motion to table the gentleman's appeal of the ruling of the chair say aye.
Aye.
All those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the motion to table is agreed to.
Thank you, Madam Chair.
Thank you, Ms. Wilson. The question now occurs on the amendment in the nature of a substitute. All those in... I'm sorry.
Yeah.
We will now take votes on the amendments which were deferred. Okay. The first vote will be on the amendment offered by Mr. Norcross, an amendment regarding the bill's definition of joint employer. The clerk will call the roll.
Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Wilson?
No.
Mr. Wilson votes no. Mr. Hunter? Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Rokita? Mr. Rokita votes no. Mr. Barletta? Mr. Messer? Mr. Byrne? Mr. Byrne votes no. Mr. Bratt? Mr. Bratt votes no. Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes no. Mr. Allen? Mr. Allen votes no. Mr. Lewis? Mr. Lewis votes no. Mr. Rooney? Mr. Rooney votes no. Mr. Mitchell?
No.
Mr. Mitchell votes no. Mr. Garrett?
No.
Mr. Garrett votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Ferguson? Mr. Ferguson votes no. Mr. Estes? Mrs. Handel? Mrs. Handel votes no. Mr. Scott? Mr. Scott votes aye. Mrs. Davis? Mrs. Davis votes aye. Mr. Grijalva? Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Polis? Mr. Polis votes aye. Mr. Sablon? Mr. Sablon votes aye. Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSagne? Mr. DeSagne votes aye. Mr. Norcross? Ms. Blunt Rochester? Ms. Blunt Rochester votes aye. Mr. Krishnamurthy? Mr. Krishnamurthy votes aye. Ms. Shea Porter? Ms. Shea Porter votes aye. Mr. Espaillat? Mr. Espaillat votes aye.
How is Mr. Hunter recorded?
Mr. Hunter is not recorded. Mr. Hunter votes no.
How's Mr. Messer recorded?
Mr. Messer is not recorded. Mr. Messer votes no.
How's Mr. Estes recorded?
Mr. Estes is not recorded. Mr. Estes votes no.
How's Mr. Grijalva recorded?
Mr. Grijalva is not recorded. Mr. Grijalva votes aye.
How's Mr. Norcross recorded?
Mr. Norcross is not recorded. Mr. Norcross votes aye.
The clerk will report the totals.
Madam Chair, there are 17 yeas and 22 nays.
The amendment is not agreed to. The next vote comes on the amendment by Ms. Fudge regarding arbitration. The clerk will call the roll.
Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Wilson? No. Mr. Wilson votes no. Mr. Hunter? No. Mr. Hunter votes no. Mr. Rowe? No. Mr. Rowe votes no. Mr. Thompson? No. Mr. Thompson votes no. Mr. Wahlberg? No. Mr. Wahlberg votes no. Mr. Guthrie? No. Mr. Guthrie votes no. Mr. Rokita? No. Mr. Rokita votes no. Mr. Barletta? Mr. Messer? No. Mr. Messer votes no. Mr. Byrne? No. Mr. Byrne votes no. Mr. Bratt? Mr. Bratt votes no. Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes no. Mr. Allen? Mr. Allen votes no. Mr. Lewis? Mr. Lewis votes no. Mr. Rooney? Mr. Rooney votes no. Mr. Mitchell? Mr. Mitchell votes no. Mr. Garrett? Mr. Garrett votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Ferguson? Mr. Ferguson votes no. Mr. Estes? Mr. Estes votes no. Mrs. Handel? Mrs. Handel votes no. Mr. Scott? Mr. Scott votes aye. Mrs. Davis? Mrs. Davis votes aye. Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Polis? Mr. Polis votes aye. Mr. Sablon? Mr. Sablon votes aye. Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSaulnier? Mr. DeSaulnier votes aye. Mr. Norcross? Mr. Norcross votes aye. Mr. Blunt Rochester? Mr. Krishnamurthy? Mr. Krishnamurthy votes aye. Ms. Shea Porter? Ms. Shea Porter votes aye. Mr. Espaillat? Mr. Espaillat votes aye.
Clerk will report the totals.
Madam Chair, there are 16 yeas and 22 nays.
What one? How is Mr. Barletta recorded?
No.
Mr. Barletta votes no.
Now the clerk will report the totals, please.
Madam Chair, there are 16 yeas and 23 nays.
The amendment is not agreed to. Mr. Scott is recognized.
Madam Chair, I ask unanimous consent that the remaining amendments, number 3, 4, 5, and 6, offered by myself, Ms. Bonamici, Mr. Takano, and Mr. Polis, be voted on en bloc. En bloc.
Without objection, the next vote will occur on the 4 amendments outlined by Mr. Scott. The clerk will call the roll.
Mrs. Fox?
No.
Mrs. Fox votes no. Mr. Wilson? Mr. Wilson votes no. Mr. Hunter? Mr. Hunter votes no. Mr. Rowe? Mr. Rowe votes no. Mr. Thompson? Mr. Thompson votes no. Mr. Wahlberg? Mr. Wahlberg votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Rokita? Mr. Rokita votes no. Mr. Barletta? Mr. Barletta votes no. Mr. Messer? Mr. Messer votes no. Mr. Byrne? Mr. Byrne votes no. Mr. Bratt? Mr. Bratt votes no. Mr. Grothman? Mr. Grothman votes no. Ms. Stefanik? Ms. Stefanik votes no. Mr. Allen? Mr. Allen votes no. Mr. Lewis? Mr. Lewis votes no. Mr. Rooney? Mr. Rooney votes no. Mr. Mitchell? Mr. Mitchell votes no. Mr. Garrett? Mr. Garrett votes no. Mr. Smucker? Mr. Smucker votes no. Mr. Ferguson? Mr. Ferguson votes no. Mr. Estes? Mr. Estes votes no. Mrs. Handel? Mrs. Handel votes no. Mr. Scott?
Yes.
Mr. Scott votes aye. Mrs. Davis? Aye. Mrs. Davis votes aye. Mr. Grijalva? Mr. Grijalva votes aye. Mr. Courtney? Mr. Courtney votes aye. Ms. Fudge? Ms. Fudge votes aye. Mr. Polis? Mr. Polis votes aye. Mr. Sablon? Mr. Sablon votes aye. Ms. Wilson? Ms. Wilson votes aye. Ms. Bonamici? Ms. Bonamici votes aye. Mr. Takano? Mr. Takano votes aye. Ms. Adams? Ms. Adams votes aye. Mr. DeSaulnier? Mr. DeSaulnier votes aye. Mr. Norcross? Mr. Norcross votes aye. Ms. Blunt Rochester? Ms. Blunt Rochester votes aye. Mr. Krishnamurthy? Mr. Krishnamurthy votes aye. Ms. Shea Porter? Ms. Shea Porter votes aye. Mr. Espaillat? Mr. Espaillat votes aye. 17.
The clerk will report the total.
Madam Chair, there are 17 yeas and 23 nays.
Those amendments are not adopted. The question now occurs on the amendment in the nature of a substitute. All those in favor say aye. Aye. All those in favor say aye. All those opposed say no. No. The ayes have it, and the amendment is agreed to. With no other members wishing to speak on the bill, I will now entertain a motion to report the bill and recognize Mr. Wilson.
Madam Chairwoman, I move the Committee on Education Workforce report the bill H.R. 3441 to the House of Representatives with an amendment and with the recommendation the amendment be agreed to and the bill as amended do pass.
The question is on favorably reporting the bill. All those in favor signify by saying aye.
Aye.
Aye. Those opposed signify by saying no. No. The ayes appear to have it. Mr. Scott asked for a recorded vote. The clerk will call the roll.
Mrs. Fox?
Aye.
Mrs. Fox votes aye. Mr. Wilson?
Aye.
Mr. Wilson votes aye. Mr. Hunter? Mr. Hunter votes aye. Mr. Rowe? Mr. Rowe votes aye. Mr. Thompson? Mr. Thompson votes aye. Mr. Wahlberg? Mr. Wahlberg votes aye. Mr. Guthrie? Mr. Guthrie votes aye. Mr. Rokita? Mr. Rokita votes aye. Mr. Barletta? Mr. Barletta votes aye. Mr. Messer? Mr. Messer votes aye. Mr. Byrne? Mr. Byrne votes aye. Mr. Bratt? Mr. Bratt votes aye. Mr. Grothman? Mr. Grothman votes aye. Ms. Stefanik? Ms. Stefanik votes aye. Mr. Allen? Mr. Allen votes aye. Mr. Lewis? Mr. Lewis votes aye. Mr. Rooney? Mr. Rooney votes aye. Mr. Mitchell? Mr. Mitchell votes aye. Mr. Garrett? Mr. Garrett votes aye. Mr. Smucker? Mr. Smucker votes aye. Mr. Ferguson? Mr. Ferguson votes aye. Mr. Estes? Mr. Estes votes aye. Mrs. Handel? Mrs. Handel votes aye. Mr. Scott?
No.
Mr. Scott votes no. Mrs. Davis? Mrs. Davis votes no. Mr. Grijalva? Mr. Grijalva votes no. Mr. Courtney? Mr. Courtney votes no. Ms. Fudge? Ms. Fudge votes no. Mr. Polis? No. Mr. Polis votes no. Mr. Sablon? Mr. Sablon votes no. Ms. Wilson?
I was going to say something.
Ms. Wilson? Ms. Bonamici? Ms. Wilson votes no. Ms. Bonamici votes no. Mr. Takano? Mr. Takano votes no. Ms. Adams? Ms. Adams votes no. Mr. Desaunier? Mr. Desaunier votes no. Mr. Norcross? Mr. Norcross votes no. Ms. Blunt Rochester? Ms. Blunt Rochester votes no. Mr. Krishnamurthy? Mr. Krishnamurthy votes no. Ms. Shea Porter? Ms. Shea Porter votes no. Mr. Espaillat? Mr. Espaillat votes no.
The clerk will report the totals.
Madam Chairman, there are 23 yeas and 17 nays.
The ayes have it, and the motion is agreed to. H.R. 3441 is reported to the House of Representatives. The chair notes for the record that a quorum is present. I now recognize Mr. Wilson.
I ask unanimous consent that the staff be authorized to make necessary and technical changes to the bill and pursuant to House Rule 11, Clause 2L. I give notice that all members have the requisite number of days to file additional or minority views.
Without objection, so ordered. I want to thank all of my colleagues for their attendance today at this markup. And as Mr. Scott has often said to me, and I agree, we may disagree on issues, but there's no sense in being disagreeable. And we have, I think, done a very good job on this bill at disagreeing and not being disagreeable. So I'd make one more announcement. Those members who are not recorded on our previous votes may have their votes recorded, provided the outcome of the vote does not change. With that, the committee stands adjourned.